Good morning, everybody. Welcome to the Tennessee Supreme Court September 2023 Knoxville docket. And welcome to all of you who may be watching the live stream on our court's YouTube channel. We're pleased to be able to present it to you virtually and in person. A special welcome this morning to our newest justice, Dwight Tarwater. This is his first time to sit with our court, and it so happens he gets to sit in his home Grand Division. So this is a special day, and we're so pleased to have him. Welcome to the court, Justice Tarwater.
Thank you, Chief Justice Kirby.
We have only one case scheduled today for oral argument. The arguments are 30 minutes per side. If the appellant wishes to reserve some of their time for rebuttal, please say so at the outset of your argument. We're ready to begin. Mr. Hibner, would you call the case?
Terry Case versus Wilmington Trust, N.A. et al.
Good morning. May it please the court, Jenna Adamson of the Nashville Bar for Wilmington Trust as trustee. I'd like to reserve 5 minutes for rebuttal. This appeal presents 3 paths to victory for Wilmington. The uniting theme is Mr. Case's fatal failure to show any damages resulting from the alleged foreclosure defect. The trustee did not violate the plain terms of the deed of trust. But even if this court disagrees, it can and should clarify that Tennessee law does not allow, much less require, rescission of a foreclosure sale based on a contractual foreclosure defect like the one alleged here. The Court of Appeals erred by holding that the trustee violated the deed of trust by ordering rescission, and by doing so sua sponte. Accordingly, this court should reverse the Court of Appeals judgment on the merits and affirm the Chancery Court's judgment. Alternatively, because Mr. Case has also failed to show a concrete injury in fact traceable to the alleged foreclosure defect and redressable by this court, the court should vacate the lower court's judgments and dismiss the appeal. Turning first to standing, I'd like to focus on Mr. Case's failure to establish the redressability element of constitutional standing. Regardless of whether he has established an injury in fact, which Wilmington contests, Mr. Case has standing only if his alleged injury is redressable by a remedy this court is prepared to give. Mr. Case's alleged injury is not redressable because he has not satisfied his burden to show that rescinding the sale would allow him to avoid foreclosure.
Ms. Adamson, if I can interrupt you there. I understand your redressability argument, I think, but I want to focus you a little bit more on the violation that Mr. Case actually alleges, which is that the notice requirements were not followed. Is it necessarily the case that he would have to actually be able to avoid foreclosure for that injury to be redressable? If the injury is that he was not given notice as required by the deed of trust, wouldn't it be sufficient to have a redo, essentially, of the foreclosure sale with the notice provisions being followed, if we assume that he's correct about the proper interpretation of those notice requirements?
No, Your Honor. The U.S. Supreme Court's precedents addressing redressability, which are persuasive in this court because the court has adopted the federal standing framework, have held that the mere correction of an error is insufficient to establish redressability. So,
is that redressability or is that standing? That seems in some ways to conflate standing and redressability. if there is no, in other words, if all that is being complained about is a failure to follow the notice requirements, and that is not in and of itself a sufficient injury to establish standing, then maybe that goes to standing and not redressability.
Respectfully, Your Honor, because redressability is part of the three-prong analysis of standing, I think this case illustrates one of those instances where the three prongs meld into each other so closely that we're really asking, is there a legally protected interest here? And we think that redressability is the clearest basis on which to hold that there is no standing here, because Mr. Case cannot stop the sale if the notice defect is corrected, but
He could get a new foreclosure sale with notice. And your position is that is not sufficient to establish either standing or redressability, or both, perhaps.
That's right, Your Honor, because the record in this case shows that Mr. Case lacks the record showed that 5 months prior to the foreclosure sale, Mr. Case had $75 in assets and $35,000 of gross income for the first 10 months of 2019, the year before the 2020 spring foreclosure sale. Mr. Case could not have paid off the loan before the foreclosure sale, and he could not have purchased the property at the foreclosure sale. And it is Mr. Case's burden to prove that he has constitutional standing at each stage. And so we are bound by the record in this case, even if another plaintiff might be able to allege facts suggesting that his injury would be redressable by the setting aside of a foreclosure sale. Those facts aren't present in this case, and we have to look at the facts here.
Ms. Adamson, I know that constitutional standing can be raised at any time, but at what point do we actually consider it here? When he filed his complaint, didn't the allegations of the complaint have, if we just stop right there, wouldn't that have shown standing?
Your Honor, the court considers standing at each stage of the litigation, but yes, he had to have constitutional standing at the beginning of the litigation.
Well, do you think, based on the facts alleged, that he had it at that point?
Well, we have to look at constitutional standing with respect to each claim, and here the only claim that remains is Mr. Case's wrongful foreclosure claim for damages claim. And so the question is, at the beginning of the litigation, did he have standing as to that claim? And we believe that the answer is no, because he could not have avoided the foreclosure sale.
Well, if the court gets past standing, which of the other two issues do you think we should address first? The notice requirement, or whether or not the wrongful foreclosure is a standalone claim?
The third issue, whether the court should recognize a wrongful foreclosure claim, is very closely aligned to standing. I think both grounds are strong bases in which to rule in Wilmington's favor.
Well, they may be closely aligned, but they're different, aren't they? I mean, the basic question is, under the common law of Tennessee, do we recognize an independent tort of wrongful foreclosure, correct?
Yes, that's right, Your Honor.
So that's not really a standing issue.
No, it's not. I think they're closely aligned in that both involve the question of whether rescission is appropriate in this case based on a record that shows no damages from the alleged foreclosure defect.
Well, but is really rescission an issue initially with regard to our determination of whether there is the independent tort or not of wrongful foreclosure?
No, Your Honor. No, it's not. So I agree with you. The court could simply hold that Tennessee law does not recognize a common law wrongful foreclosure claim, and it wouldn't necessarily have to reach the question of whether rescission is available if it didn't recognize that claim.
But would we then have to consider whether the breach of contract claim is viable? I mean, even if we hold that there is no independent wrongful, independent, wrongful foreclosure claim, that wouldn't preclude a plaintiff from bringing a breach of contract or some sort of tort claim. You could imagine a fraud claim or something along those lines stemming from a foreclosure proceeding. It's just that they would have to fit that claim within the traditional elements of that common law cause of action rather than having this nebulous standalone wrongful foreclosure claim. So would we still need to examine whether a breach of contract claim, for example, here, whether Mr. Case should have prevailed on the breach of contract claim?
No, Your Honor, you would not have to do so because Mr. Case has not challenged the Chancery Court's dismissal of his breach of contract claim for lack of damages. So he has not challenged the underlying factual finding that he doesn't have damages, and he has not challenged the dismissal of his breach of contract claim. So the court would not need to reach that issue.
Could we turn back just for a moment to standing? I do want to ask you about standing within the kind of the traditional breach of contract case. I mean,
Yes.
What sets this case apart, in my view, from some of the U.S. Supreme Court precedents you cite, such as Spokeo and TransUnion, is that we're dealing here with a common law cause of action rather than a statutory violation. And some courts and commentators have distinguished between those situations and have said that where there is a kind of violation of a traditional, or where there is a traditional common law cause of action and a violation of a private right that is protectable, by that common law cause of action, that there is necessarily standing, even if there is not an injury in fact. Is that something that this court could adopt or should adopt?
So, Your Honor, I think Justice Thomas's dissent in TransUnion exemplifies this view that a private right conveys, the violation of a private right conveys standing. I think the reason he was in dissent is that the rule that the court adopted in TransUnion suggests that as long as there is no concrete harm associated with a legal violation, which could be the violation of a statutory right or could be the violation of a contractual right, then standing is not established. And the Fourth Circuit in Food Buy applied that reasoning to a breach of contract claim. Because this court has adopted the federal standing framework, including the requirement of an injury in fact, I think it follows that the court should very closely consider and perhaps adopt the U.S. Supreme Court's precedents as they continue to evolve in the interpretation of the injury in fact requirement.
But would you acknowledge that area of the law, specifically as it pertains to a breach of contract action, for example, remains a bit unsettled even after the U.S. Supreme Court's decisions? I mean, we've got U.S. Courts of Appeals going in different directions on that specific issue.
Yes, Your Honor, we acknowledge that. We cited the Fifth Circuit decision holding the opposite of the Fourth Circuit, recognizing that breach of contract does establish standing. That's in part why we think that the redressability prong is the strongest basis here to find that there is no standing.
Counsel, if I might back up a little bit, what is the bank's position, the lender's position on compliance with the notice requirements in the deed of trust and in the notice of sale? I'm looking at your deed of trust. It says all notices must be in writing. Were all of your notices in writing?
Your Honor, the way that courts have interpreted that provision, which is a standard provision in the Fannie Mae Freddie Mac deed of trust instrument, which governs hundreds of thousands of loan transactions in Tennessee and across the country, is that That is a general provision that requires written notice only as to specific events that are specified in the deed of trust. So in paragraph 22, the deed of trust requires written notice as to acceleration and as to the sale. So Wilmington's position is that the deed of trust is silent as to notice for postponement. Wilmington also argues that the notice of sale does not require written notice of a postponement, and that the Court of Appeals erred by holding that it did, and applying the last sentence of the notice of sale to the entire paragraph.
So all notices means all notices except for notices of postponement?
No, Your Honor, all notices means the phrase in the deed of trust is all notices in connection with the security instrument, which courts have interpreted to mean notices specified in the deed of trust. Our amici has explained that the legislation at issue here was specifically designed to cover this sort of deed of trust instrument that is considered by the industry to be silent on the question of postponement. So the statutory provision was enacted to provide guidance to a trustee in this sort of situation where the deed of trust says nothing about what is required with respect to notice of a postponement.
So all doesn't mean all?
Your Honor, that is not the way that courts have interpreted that provision. Again, it's a general provision. But even if the court disagrees with us on that point, that very paragraph that has that language concludes with an applicable law provision. And the applicable law provision provides that if both the security instrument and applicable law require notice, then satisfying the applicable law requirement will satisfy the requirement in the deed of trust. So even if the court finds that the deed of trust required written notice of a postponement, if, as is undisputed, the trustee complied with the statutory requirement for orally postponing a foreclosure sale for less than 30 days, then the trustee did not violate the deed of trust.
Well, let's talk about that if we might. The applicable law provision talks in terms of requirements, right? Required notice. Do you find that the postponement statute is a required notice or a permitted notice?
Your Honor, it's a required notice. It does require notice in a different form than written notice, but it requires oral notice at the date, time, and place of the original sale. So if the trustee had not orally postponed the foreclosure, the original foreclosure sale in compliance with that statutory provision, then Mr. Case could have sued, arguing that the trustee violated that statutory provision, which clearly indicates that the statute requires notice of a postponement.
And so if we look at the statute, I'm assuming that Section F2 of the statute says that each postponement, quote, must be announced.
Yes, Your Honor.
Is that the required language that you have reference to?
Yes, Your Honor. The language must or shall generally indicates a requirement under the statute.
Yet, 2 paragraphs before, the statute uses the terminology may, right? Any sale hereunder may be rescheduled, right?
Yes, Your Honor. May is used in reference to the idea that if the trustee decides to postpone the sale, it may do so. It does not reference the requirements that the trustee must satisfy when it elects to postpone the sale.
All right, so one more question here on my first day. Can the parties agree that the oral postponement statute does not apply?
No, Your Honor. The statutory framework governs all foreclosures in the state of Tennessee, which is partly why Wilmington argues that it is unnecessary for this court to recognize a wrongful foreclosure common law cause of action.
Well, I understand that, but I just violated my own one more question rule.
We were
But-
expecting that.
But it seems as if the argument is that your first argument is the bank did everything right, right?
Yes, Your Honor.
Okay. And then the second argument is if we didn't do anything right, he wasn't hurt by that.
No, Your Honor, our argument is that Mr. Case has not established damages and that there is no wrongful foreclosure claim available under Tennessee law, meaning that the Chancery Court's judgment with respect to his breach of contract claim would be determinative in this case.
Ms. Adamson, is your best argument, or at least one of your best arguments, a policy argument to us in that if we uphold the Court of Appeals, it throws hundreds, if not thousands, foreclosures into question, and I guess title of those properties are now uncertain?
Yes, Your Honor. The statutory scheme governing foreclosures in the state of Tennessee dates to the mid-19th century. It's very old. In particular, the provision for damages alone for a breach of a statutory foreclosure requirement and the prohibition on rescission of a foreclosure sale for any defect, not just a harmless defect like we have in this case. And so the Court of Appeals interpretation has essentially authorized a second path that throws into doubt title for involved in any transaction involving a deed of trust. And as I have explained, this deed of trust is the standard deed of trust used in the state of Tennessee. So any decision with respect to the interpretation of this deed of trust will affect many transactions.
Can I follow up on that and ask if you could just explain your position on the relationship between the statutory framework and common law causes of action? I mean, you've referred to the statutory framework in arguing that rescission should not be an available remedy, even if there is, some sort of independent wrongful foreclosure cause of action. But, generally, we presume that the legislature has not intended to abrogate the common law. So even setting aside whether there's an independent wrongful foreclosure claim, you could allege violations of the deed of trust as a breach of contract claim, as was the case here. And traditionally, rescission is an available remedy, although, albeit one that is an extraordinary remedy that should be sparingly granted, for breach of contract. So is it your position that the legislature intended to abrogate that part of the common law? And if so, what can you point to in the statutory framework as evidence of that? And if you could just elaborate a bit on the relationship between the statutory framework and other causes of action that could be brought stemming from a foreclosure sale.
Yes, Your Honor. So I think Holt presents a good example of the foreclosure context in which you could have rescission and that the statutory framework doesn't touch. So if there was an inadequate price at the foreclosure sale and there's evidence of fraud or oppression or something like that, the Holt rule, which isn't involved here because we're just talking about an alleged contractual violation, and in that case, the sale was conducted in compliance with both the deed of trust and the statute. The question was whether the price was inadequate. That sort of situation is not touched by the statutory framework. I think it's very interesting if you go back and look at how the old cases, Henderson and McIntyre, that plaintiff relies on, have been cited. They were not cited for the rule that plaintiff cites them for until a 2002 federal bankruptcy case. This suggests to me that that court and Tennessee courts of appeals that have followed that reasoning have misdeveloped the common law, that they took a rule that hadn't been fully developed or accepted in the Tennessee common law and started treating it as a separate means of setting aside foreclosure sales.
And the principle you're referring to is just that if you have a violation of the notice provisions, then the sale is void.
Yes, Your Honor. Yes. So I think the statutory framework, it is possible for the statutory framework and a common law framework to exist side by side. What we argue is that this sort of elementless wrongful foreclosure claim is an improper development of the common law, that the common law already has a breach of contract claim and remedy for plaintiffs, for borrowers in this situation, and that this recognition of a wrongful foreclosure claim is not only incompatible with the statutory scheme, but ignores the fact that there's already a sufficient remedy under the common law. And I see my time is ending.
Pretty well, didn't you?
Thank you, Your Honors.
Good morning. Excuse me. Buddy Presley, may it please the court, Buddy Presley of the Chattanooga-Hamilton County Bar. I've got Terry Jones here, who has worked with me on this, and then there's our client, Terry Case, in this particular matter. Your Honors, I really want to set the framework for this because this case is unique. This was a case that was originally filed to stop the foreclosure. And I have filed hundreds of them. Hundreds. I stopped the foreclosure. Stopped it. Didn't happen, the first one. So we were in litigation. This was a plaintiff and a defendant. And I go to the Chancery Court and I get an ex parte order and it gets set for a TRO hearing. I stopped the foreclosure. At that point in time, I was never noticed as counsel. My client was never noticed. I was never told, even though I was in communication, I was never told that, no, we had just orally reset this foreclosure. I give that framework because this is not, I got foreclosed on and I'm coming back in trying to undo this. This is fundamentally wrong. My client lost his house and he didn't even know it. And I didn't know it. And I was the plaintiff's lawyer. And he lost his house. They took it.
But you are aware of that statute. You are aware of the statute that outlines how a postponement occurs and how notice is given.
And if you'll read the very beginning of that statute, and I've detailed it, the very beginning of that statute, that's a publication statute. That's not a notice statute. That's a statute which determines when you have to republish the notice. In this particular case, I noticed counsel pointed out this is a deed of trust that is a form document. I've seen it. I've been practicing 35 years. I commented I was here 27 years ago. It's taken me 27 years to get back to a Supreme Court case. But that is a form that's used everywhere. Paragraph 15 is in every one of these deeds of trust. I have reviewed deeds of trust my entire career. And I have always been aware of the fact that that deed of trust requires written notice. There's been a whole lot of convolution around, let's see if we can somehow argue ourselves out of the fact it says you have to provide written notice. It can't be any clearer. You have to provide written notice. The statute on the postponement is whether or not you're going to have to publish it again. There's nothing in that statute which says if you are less than 30 days, you don't have to give any sort of notice. It doesn't say that. It talks about publication.
But so in essence, what you're arguing, Mr. Presley, is the breach of contract claim, correct?
Well, we had argued both, and if I can set that framework, this was originally, this case got here on a motion to dismiss filed by the defendants. It was then, by the chancellor, converted because they had 800 pages of attachments. It was converted to a summary judgment motion.
All right.
We clearly pled wrongful foreclosure, and the statement was that the appellate court, which we think got it right, sui sponte, it wasn't sui sponte. We had argued the point. We had
Argued rescission?
We had argued.
Had you argued that that should be the remedy?
We had argued wrongful foreclosure, which the only remedy to wrongful foreclosure would be the rescission. We had also argued breach of contract.
Did your complaint seek rescission?
Ma'am, I'm sorry.
Did your complaint seek rescission?
If I remember correctly, we did seek rescission. All other remedies under law is.
So it was in the catch-all.
Yes.
Why would rescission be the only remedy under, assuming that there is an independent tort of wrongful foreclosure, why would rescission be the only remedy?
Because we've got 100.
Monetary damages be awarded under certain circumstances?
You could have monetary damages in the event that the foreclosure was set aside. The remedy in the independent wrongful foreclosure action has been you've taken someone's property wrongfully for whatever reasons. A lot of the cases, the cases out there don't cite this particular instance. And when they talk about the sky is falling, it's going to undo tens of thousands of mortgages. This case is unique. The notice provision in this case is unique. The actual notice of sale that was published is unique. The argument that...
Wait a minute. You just finished saying that this is a deed of trust that is used almost universally.
Universally. The deed of trust says the notice of sale is not used by everybody. That particular notice with the paragraph at the very end, which provided in such situations, a plural, and the appellate court picked up on that issue that the chancellor had denied, was that applied to all postponements. And so my argument...
I'm sorry, go ahead and finish.
The argument is that this is not going to undo tens of thousands of mortgages. That's not going to happen.
So are you claiming the deed of trust used by Wilmington is unique?
No, I'm not claiming that's unique. I'm saying the notice of sale is different than the notice of sale used by other people in the foreclosure industry.
So the deed of trust incorporated the notice of sale by reference.
By reference.
Okay,
Yes,
so it's
ma'am.
part of the contract, but the notice of sale varies from transaction to transaction.
Well, it varies from law firm to law firm to law firm. Everybody's notice is a little bit different. We think the appellate court got it absolutely correct, that there is an independent cause of action in wrongful foreclosure, and that the nature we focused on, and it's bled into a standing argument too, of, okay, you didn't prove damages. That's why the breach of contract claim was denied. Because
Mr. Presley, you're only seeking rescission here, not monetary
correct.
damage,
We're only seeking rescission.
So if we rule in your favor, what happens next?
Well, Your Honor, I don't know what may or may not happen. What's not in the record is the fact that there was an eviction that went on. So I guess there's going to be an issue related to a wrongful eviction. But what's going to happen next is the same thing that could have happened, and I think it was alluded to by one of the justices. What could have happened in this case, they could have re-foreclosed. and they didn't. So we're here at the Supreme Court now arguing this case when they could have just re-foreclosed.
Well, wouldn't that happen anyway if we rule in your favor? Just
I don't know.
All we have is delay here, right?
Say that again.
All we have is a delay. The outcome is going to be the same.
And I don't want to predict the future, because I do think there potentially are other causes of action that could be brought in what may be, Wilmington case versus Wilmington number 2. I don't know. I just know at this point the appellate court was clear, and I think they upheld what is now 175 years of jurisprudence. The Henderson-Galloway case was 1848. Said strict compliance. This is the effect of, if you're going to take someone's property, if you're going to take their property right, and my position is that when you take that property right, that's the damage. It's inherent in the cause of action. You can't have a foreclosure without something being taken away, a property interest taken away from someone.
But you didn't bring this as a property case. I mean, you didn't bring a trespass action. You didn't bring a wrongful eviction. I mean, there are property law-based causes of action that would remedy a violation of a property interest, but that's not how you brought this case.
And you're absolutely correct. That's not where we were when this case started. And when it went through the summary judgment phase and then to the appellate phase, we did not have those particular claims at that point in time. We brought this, and our argument has always consistently been that if you're going to take someone's property in foreclosure, you have to do it right.
So what is the distinct and palpable injury that forms the basis of the claims that were actually brought, in particular the wrongful foreclosure claim? I mean, you've alluded to this property interest right, but if we look at specifically the cause of action that was brought, what is the injury that cause of action seeks to remedy?
That he lost his house and everything that was in it, and everything that was in the...
So it's not that there was a violation of the notice provisions, because that's really a distinct injury, right? That is a different injury than losing the house.
Well, I think the violation of the notice provision is what gives us the ability to then bring a wrongful foreclosure action for the fact that he did lose his house and his business and everything else that was on the property.
Is it your position, Mr. Presley, that the breach of contract claim is properly before this court?
No, I think the appellate court, I'm going to be difficult to get past the argument that the appellate court had and stated that we did not argue that at the appellate level. We did not argue the breach of contract at the appellate level. And so I don't believe that I can then reverse that. And I don't think I'm going to be successful. And I hate to stand up here and give up on a claim, but I'm also practical in that that's not where the appellate court found basis for their decision to hold that the sale was void. This is basically a fairly straightforward matter in the sense of the notice of sale says what it says. We didn't draft it. We didn't draft the deed of trust, and my client's not in a position to even negotiate that language or the drafting of that. He didn't have the defendants in this case they owned and had the deed of trust that was provided at the time of the mortgage was put down, and they also prepared the notice.
If you're saying that the notice of sale was incorporated into the deed of trust, did I understand your argument correctly?
I think the deed of trust, I don't use the term incorporated. The deed of trust calls for clearly there has to be a notice of sale. That's a clear black letter law that when you foreclose on someone, you have to provide a notice of sale. It's clear that notice has to be published.
I think my question is with regard to not complying with the notice of sale, that has to hinge on the deed of trust, which goes back to breach of contract, doesn't it?
Well, it has to hinge on the deed of trust and the provisions providing for what you have to do when you foreclose on a
Isn't
property.
that breach of contract?
And that could incorporate a breach of contract claim, absolutely.
What else? I mean,
The
it
wrongful
has to,
foreclosure
right?
came.
Well, so the only other path is if we have an amorphous, freestanding wrongful foreclosure common law cause of action. I mean, you've got a wrongful foreclosure action that could arise out of the statute, wrongful foreclosure that could arise out of the breach of trust, and then the only other is some kind of freestanding wrongful foreclosure based on I'm not sure what.
Well, in my opinion, that's what the Tennessee courts have held for 175 years.
And
is that there is
you're
a separate-
riding the independent, you're riding the horse of the independent wrongful foreclosure claim, right?
Which is exactly what the Court of Appeals said.
Okay, all right.
So
That's
let
helpful.
me ask you, counsel, back to the notice of sale. Is that the crux of your argument? Is that the basis of your argument that written notice was required in this situation?
I believe strongly and legally that the written notice was required. And I go back to where I framed this originally. Not only was it required by the actual language in the notice, but I believe, and this has been argued, this has not been waived, I believe it was also required because we were in litigation. I can't be in litigation with a litigant who is going to not tell me certain things of what's going on procedurally.
Did you show up for the preliminary injunction hearing?
I did not go because I have done hundreds of these, and in that particular instance, usually almost uniformly, when the foreclosure is put off, we withdraw our motion. For some reason, whatever reason, we did not withdraw our motion. And so the motion was heard and I was not in attendance, so the TRO was dissolved.
And no, neither you nor your client attended the original
Foreclosure sale.
foreclosure sale, right?
No, because I was told clearly that it had been canceled, not that it had been postponed.
All right, and so the bank goes and they announce that the sale's going to be in 2 weeks. And you say that's not enough, right?
I say that's not enough under the law.
And the reason that you say that is because of the notice of sale.
And also the deed of trust clearly says all notices have to be in writing.
Well, but what would you point to in the deed of trust for there being a notice requirement to begin with? I mean, do you have to then go to the notice of sale to find the requirement that notice be provided in the case of a postponement?
I think the first paragraph in paragraph 15 says all notices must be in writing.
Right, but that kind of begs the question of when a notice is required.
It would go to when notice is required. I agree with that statement.
So where do you find the requirement of notice in this particular situation? That's the notice of sale?
Well, it would have to be the notice of sale for sure, and that's clearly been one of our arguments. I think it would also have to be the fact that we were in litigation and we were litigating this particular case. And I think I was entitled to notice of a sale for no other reason under the ethical rules regarding the fact that we were in litigation.
But that's not what your claim, on what your claim is based. No. I mean, you really
My
are
claim
basing
is
this
on
the deed of trust and notice of sale.
Yes, ma'am.
Okay.
All right, so following up on what Justice Campbell just asked, I'm looking at the notice of sale. I've got it before me. You tell me what you are relying on for the proposition that written notice is required.
The very last paragraph in that.
Okay, it says in such situations. How do you interpret that?
This is the way the appellate court interpreted it, that it meant the three situations that preceded that sentence, and in common English, that would apply to those three situations.
Inclement weather?
Inclement weather,
are the other two?
That, I think it uses the term, and I was trying to pull the exact language up, that any other reason or any other circumstance.
Well, such can't mean everything, right? Such can't mean all, or they would have said, in all situations, there must be written notice, right?
Well, I think in just isolating the word such, I don't think I could disagree with you completely, that such would mean everything, but in that instance, the drafting of that was that written notice would be provided in all other situations, written notice would be provided.
But it's following the sentence about inclement weather.
It is following, and I think the appellate court came down with their analysis of that based on the reading of the English language and the understanding that when you have a sentence at the end of a paragraph that says in all such situations, that it would apply to everything that preceded that.
All right, so let me just ask this. What in your view, what should the bank have done? Mailed a notice to you and to your client?
Well, because I was in active litigation, yes. I think I should have got a copy of a notice, and I think my client should have been mailed a copy of the notice.
By mail?
By mail.
Or hand delivery
Email.
or whatever. No,
I mean,
you know, the postponement statute, as you argued earlier, has to do with publication, certainly. But you're not talking about publication here. You're talking about actual written notice that you and your client should have gotten actual written notice of the new date of sale.
just like he did get it for the initial sale that was scheduled. We've never argued that he didn't get written notice for it.
And the postponement statute does not apply because it's, in your view, it does not apply because of the notice of sale.
The postponement statute is not relevant to written notice related to a postponement. The postponement statute, we call it the postponement statute, but it's the publication statute discusses when you would have to republish a notice of sale in the newspaper. Therefore, what we would call constructive notice. And it doesn't talk about providing a written notice when the sale is postponed for less than 30 days. And we have to remember, this was postponed the day of or the day before the world came to an end, the day before COVID, the day before foreclosures were banned for a while. The postponement was strategically, in my mind, coordinated by the defendants.
So doesn't the postponement statute, I understand your argument about publication, but doesn't the postponement statute specifically permit notice by mail? It looks like it does to me in paragraph 3. If it's more than 30 days, notice must be mailed.
Notice must be mailed. If it's more than 30 days, correct. Notice must be mailed. And that's clear. That's number 3 in the statute. There's 4 provisions in that statute. They all really deal with publication.
Well, except for the provision you just mentioned, subsection 3, which specifically deals with notice by mail for postponements of over 30 days. I mean, is it your position that, well, it's silent as to what kind of notice, if any, is required if the postponement is less than 30 days?
My position is that the law, the statute, does not provide us, and it is silent. I will admit that clearly, is that the law does not tell us what happens under the statute if it's less than 30 days. The contracts do, and the notice of sale does.
Is it correct to say that your claim pivots on how we interpret the word such in the notice of sale.
Well, or the word situations.
All right. Let me
yes.
clarify then. Does your claim pivot on how we interpret the phrase such situations in the notice of sale?
I think that
If it includes all of the reasons, you would prevail. If it is, we interpret it as referring only to a postponement for inclement weather, you fail. Is that right?
I think, Your Honor, it would be correct to say that the critical issue in this case is obviously notice and whether notice was required.
That's the big issue. I'm trying to figure out the determinative pivot point. Is that the pivot point? If it's not, explain why it's not. But tell me a yes or a no.
I think, Your Honor, that would be the pivot point.
Okay.
That would be the pivot point, because and the appellate court was pretty clear in its analysis of that sentence and that phrase, and I think it was clearly a pivot point in the appellate court decision. I think that the discussion of that with trying to interpret a provision that is after several other provisions and how it applies is good law and good explanation. But I think you're correct that if you were to read that, then the whole argument we've been making in this case would falter to some extent.
Okay.
That's not the way we read it, but
I get it. I'm just trying to, there are a lot of sub-issues. I'm trying to figure out the determinative ones.
and I guess I keep coming back to that this case is not, this case has been made inordinately complicated. When you get into redressability and standing arguments and issues related to that, it becomes extremely complicated in the sense of what moving part are you looking at? Our position is that we were in litigation over a foreclosure and we did not get notice of it.
Yeah, but
that's not
that's
before
more of a
us.
do-right argument.
Well, that is in the record, but it's the fact we were in litigation is in the record. That's not before you based on that particular
We can't grant
ground.
relief to your client based on that, correct?
You can't grant relief
So
to my
why
client
are we even
based on
talking about it?
Well, because I think it's lost in the sense of that this case is about my client who lost his house. He lost it.
Let me ask you about the remedy here. The appellant, Wilmington, argues that the trial court's initial decision, to the extent it involved any sort of remedial decision, that the standard of review for that is an abuse of discretion standard. And, ordinarily, suppose the trial court here had awarded rescission as a remedy, ordinarily that would be reviewed for abuse of discretion. Do you agree with that is the standard of review that applies to the trial court's decision on, the trial court didn't award a remedy because it found that the claim failed, but to the extent there was a remedial decision, is that what we're dealing with, an abuse of discretion standard?
Well, and I believe that a remedial decision such as rescission or whatever, the rescission part of it, would be viewed by this court under an abuse of discretion. But did
the Court of Appeals err in that regard and not, remanding it to figure out what the appropriate remedy should be so that decision could be afforded
and we're talking about the
a more
appellate.
deferential standard of review?
Yes, ma'am. And we're talking about the appellate court decision.
That's right.
Is that I don't think the appellate court erred in the sense of that we have a long history of decisions which say the remedy in a wrongful foreclosure is the sale is void, which is rescission. Because the sale is as if it's not voidable It's as if it didn't occur. Now,
So your position is that under that precedent, once a court finds that there is a violation of the notice provisions, that has no discretion as to remedy. It's just the sale is void.
And I would take that position, and I would say that in this country, we have 30 states that allow non-judicial foreclosures, and that's what this was. And I believe that the Tennessee Supreme Court has consistently said that in these instances, we're going to strictly enforce compliance because of the nature of the action is so dramatic. It's not a situation of where you had a car wreck and got hurt and we're going to give you money. It's that you took property that belonged to me, you took it away from me, which is fundamental. That's why we probably don't have 50 states that have non-judicial foreclosures, because non-judicial foreclosures inherently lend themselves to mistakes or things occurring that should have happened and didn't happen. In this case, the notice is what didn't happen. Now, I haven't touched that much on, and it seemed like in the original, in the appellee, appellant, I haven't touched that much on standing. It's our position that inherently our client has standing because he owned the property that was taken away, and that he has to have standing in this particular case because this is the nature of this action, is that you're going to take something away from him.
But doesn't the cause of action have to be related to the injury? I mean, this brings me back to the earlier discussion we had about, your claims, at least at, in this litigation, not being property law claims.
And I'd say that again, I got like 2 seconds.
You can answer Justice Campbell's question.
I just go back to this fundamental position, is that owning property and possessing it is a fundamental right in this country. And that if you're going to take it away, you better make sure you do it right. Even if you make the slightest mistake, they call this harmless error. It's harmless error that cost my client his house. That even if you make the slightest mistake, you still ought to be corrected. And the correction in this is what the appellate court said, which we're going to void the deed. We're going to void the sale. And you're going to get your property back.
Thank you, counsel.
Thank you.
Your Honors, I have a few points on rebuttal. The first, to Justice Kirby's question, the question of whether the trustee violated the deed of trust turns on the phrase "in such situations." But the only way that the notice of sale is relevant is if it was incorporated into the deed of trust. And that means that if the notice of sale required written notice of a postponement, then the deed of trust required written notice of a postponement, which means the applicable law provision would be triggered. And if the applicable law provision is triggered, then so long as the deed of trust and the statutory scheme required notice of the same event, and the statutory scheme here required notice of a postponement of sale of less than 30 days, then satisfying the statutory requirement would also satisfy the requirement under the deed of trust, meaning that the trustee complied with the deed of trust when it properly orally noticed the postponement.
Okay, so you're saying that even if we were to interpret such situations to refer to any kind of reason for the postponement, then it goes through the deed of trust to the statute, and the oral postponement was sufficient.
Yes, exactly, Your Honor. The notice of sale simply isn't relevant to the question of whether the trustee violated the deed of trust unless it was incorporated into the deed of trust. And then you have to look at that applicable law provision.
But we would
Is it
reach
your position that it was not incorporated into the deed of trust?
We think based on the deed of trust provisions that it was incorporated. The deed of trust requires that any foreclosure sale be conducted in compliance with the terms of the notice of sale.
Okay, thank you.
To Justice Tarwater's point, we agree that such can't mean anything, so we don't, or it can't mean everything, so we don't think that the notice of sale required written notice. I believe it was Justice Campbell that pointed out that Mr. Case pursued wrongful foreclosure for damages, and Mr. Case's counsel conceded that they have waived their breach of contract claim. So that means that the question of whether, assuming that the court decides not to recognize an independent wrongful foreclosure claim, this court need only affirm the Chancery Court's judgment. Mr. Case's counsel suggested that the statute here was a publication statute. That's not the case. When we interpret statutes, we don't look at just the title of the statutory provision. And in this case, this statute requires written notice not only in the specific provision addressing notice related to a postponement, but it also requires in 35-5-101E in any sale of land to foreclose a deed of trust. The trustee or other party that sells the property shall send to the debtor and any co-debtor a copy of the notice. So the statute addresses both publication and notice. Mr. Case's counsel also suggested that affirming the Court of Appeals interpretation of the deed of trust would not affect other transactions. That is not the case because the Court of Appeals mistakenly interpreted the deed of trust applicable law provision and held that the statute does not require notice of a postponement of less than 30 days. So that is an interpretation, both the interpretation of the statute and the interpretation that the deed of trust applicable law provision does not apply in this case would affect many transactions across the state. And Wilmington also agrees that Mr. Case has waived any argument with respect to whether counsel received notice of the postponed sale. If the court has no remaining questions, Wilmington asks that this court reverse the judgment of the Court of Appeals on the merits and affirm the Chancery Court's judgment, or alternatively, that the court dismiss this appeal for lack of jurisdiction. Thank you, Your Honors.
Thank you, counsel, for your hard work and fine arguments. The court appreciates it. Mr. Hibner, I believe that's our only case. We stand adjourned.
All rise.